approximately 6.5 million Americans working in the construction industry, it is no surprise that construction accidents can lead to personal injury cases. And unfortunately, those injuries can sometimes be very, very serious. And that's not a surprise, I'm sure. Many of the injuries come about because there's inadequate fall protection for the workers. And there are entities who are responsible to ensure that there would be appropriate fall protection. And the sites of the lawyers' focus usually is on the general contractor, the entity who is charged with superintending and overseeing the construction project. Now, I'm speaking about workers, but I want to point out again, as I have in past blogs, that bystanders or third parties who are not part of the construction work can also bring suit if they should be a passerby and get hurt by what's going on in the construction enterprise. This is nothing meant to depart from that, but I'm focusing now on the workers. And I'm focusing on the worker, usually somebody who's employed by a subcontractor on a large renovation or building construction, and that person cannot sue his or her employer. In tort, they get workers' compensation, but in tort, they can sue the general contractor. And in Massachusetts, I'm happy to report that the obligation on the general contractor is a non-delegable duty of safety. And there are many different sources or reasons for that. Number one, the contract between the owner and the general contractor typically establishes that the general contractor must comply with all safety regulations, rules, laws, and ordinances, and failure to do so is a violation of that contractual provision. But there are also OSHA regulations, and there are also state regulations that are known from the Commonwealth of Mass regulations that impose the specific requirements for the construction industry and for safety on a job site. And they're quite direct and quite explicit. And for example, you would say under the OSHA regulations that 1926 will tell you very much what is expected of a general contractor. And in establishing that responsibility and in establishing that liability, you look to, as I say, the contracts, you look to permits, you look to other things on file, and in the course of it, of course, as a plaintiff's attorney, you will hire experts. Some might be very OSHA-type specific experts, and others maybe just have a lot of familiarity with what good and safe construction practice is. So these are involved cases. Often the injuries, unfortunately, are very, very bad. And there are enormous amounts of documents and sources in which a careful and diligent plaintiff's lawyer can find liability. There should be minutes of what's gone on in terms of meetings. There should be site-specific safety plans. There should be safety manuals. And all of these exist in addition to the contract I spoke about, which imposes certain duties upon the general contractor, as well as state regulations pursuant to the Commonwealth of Mass regulations, 780 CMR and 454 CMR, as well as federal regulations under OSHA, an entity that we're all very familiar with. Thank you.